Your knowledge of contract language is imperative.
You must know what a violation looks like if you wish to be active in its cessation.
It is important to understand that being active and knowledgeable affects your overall bargaining strength.
Together, we can forge a more militant NALC.
Good morning and welcome back to Parcels of Knowledge, that podcast dedicated to delivering knowledge to the city letter carrier with your host, the Roseville Wrecking Ball. Before we get into the grit, I do want to remind you guys that in December, we'll be having an interview with Corey Walton regarding his run for Executive Vice President. You guys are tasked with coming up with questions to ask him. Ask him anything you want. Softballs, hardballs, everything is welcome here on Parcels of Knowledge. Let's get to know our candidate. Please submit your questions to rosevillewreckingball@yahoo.com, and I will ask anything submitted. I will link that email in the episode's description. I will need your answers on or before November 30th because we all will be likely recording the episode on November 30th. So, you've got less than 2 weeks left, and with Thanksgiving right around the corner, please submit me those questions. We definitely need more questions. Submit them to me, please. Okay, so in this episode, I will do something a little bit off the beaten path. I know that's kind of what I'm known for, but it's off the beaten path for myself. I think this episode will be a two-parter since there's a lot of ground to cover. I know I have released over 50 episodes now, and I have discussed a lot of things. But today, I will be testing that knowledge. Think you have what it takes to get in the ring with management and come out on top? Are you cut out for being the best steward you can be? I'm going to go over what is called a Black Book. I believe this book is usually used to train people who are going to go to do the Step B test or something of that nature. It is a question and answer format. This one is going to be true or false format. I will go over the first 150 questions of the Black Book today, and the other half on a near future episode. And at the end of each question, I will give the answer. Let's see how many you guys can get right. Alright, are you guys ready? Here we go. Number 1. Temporary supervisors, 204Bs, continue to accrue seniority in their craft during the time they serve as temporary supervisors. This is true. You can find that in C03227. Number 2. A 204B working in the city letter carrier craft can voluntarily waive out-of-schedule pay while on detail to a higher level assignment and if worked outside their bid schedule. False. That can be found in C00161 and in the JCAM on page 8-6. The only provision for waiving out-of-schedule pay is when the individual assigned to the higher level detail fills out a Form 3189, which is then signed by both the employee and the steward. Steward should not sign the form in these circumstances. So in that case, 204Bs can't waive it alone. It's going to require a steward, and 3189s are supposed to be filled out for personal convenience, not for business needs. Number 3. Management is under no obligation to inform the union of who has been assigned to a 204B status. False. You can find that in M00030, M357, and Article 41.1.A.2. Management's contractually bound to provide the local union with copies of Form 1723, which includes the employee's name as well as the beginning and ending dates of the higher level assignment. Number 4. Management may use a craft employee in a 204B assignment for less than a full day. True. That can be found in M537. Any amendments to Form 1723 must be provided to the union. Number 5. An officer in charge assignment is regarded as a temporary detail per Article 41, Section 1.A.2 of the National Agreement. True. That can be found in M document 00249. Number 6. A 204B may not serve as the management representative in an informal A grievance meeting per Article 15, Section 2, Informal A of the National Agreement. False. That can be found in M document 824. Number 7. A 204B may serve as a 204B for an unlimited amount of time and still retain their bid assignment as a letter carrier. False. You can find that in Article 41.1.8.2. A 204B assigned as a temporary supervisor may not serve in that capacity in excess of 4 months, or their route is declared vacant and should be posted for bid in accordance with Article 41. If the individual returns to the craft after that date, they are an unassigned regular. That individual may rebid their assignment if they are working as a letter carrier during the job posting. Number 8. A 204B may return to their route for a short period of time in order to circumvent the intent of Article 41.1.8.2. False. M document 11. Number 9. Management may not prematurely terminate a 204B assignment. False. M document 789. Number 10. A 204B may not be utilized in lieu of a bargaining unit employee for the purpose of bargaining unit overtime. True. M document 506. An employee detailed to an acting supervisory position cannot perform bargaining unit overtime immediately before or after their detail unless all available bargaining unit employees are utilized. Number 11. A 204B may not sign the overtime desired list. False. M document 747. A letter carrier may sign the overtime desired list according to Article 8, Section 5A if they are not in a 204B status during the sign-up period. They may not perform overtime within the letter carrier craft within the beginning and ending times of Form 1723. Number 12. A 204B may not opt for available temporary assignments of 5 days or more. True. M document 552. Number 13. A 204B may not bid on vacant letter carrier craft duty assignments. True. M document 0016 and Article 41.1.8.2. There is nothing that would prohibit the 204B from voluntarily terminating their assignment and returning to the craft position in order to exercise a bid under Article 41. Number 14. A 204B who is disciplined for an act while actually serving as a supervisor is represented by the NALC and by the NAPS. Let me repeat that. A 204B who is disciplined for an act while actually serving as a supervisor is represented by the NAPS. False. JCAM page 1-3. Per Article 1 of the National Agreement, until the 204B becomes a permanent supervisor, they are represented by the appropriate craft union. All right, we're done with 204Bs, I think. Number 15. When supervisors perform craft work in violation of Article 1, there is no remedy if the amount of time is de minimis. True. JCAM page 1-5. If, however, the amount of time is not de minimis, the employee identified by the parties will be compensated the appropriate rate for an amount of time equal to the amount of time the supervisor spent performing unit work. That was a tricky one because I think they're referring to monetary remedy, not remedy. There's going to be a remedy no matter what, usually a cease and desist. Number 16. Supervisors may case mail into letter carrier cases. False. M document 832 and JCAM page 1-6. If the phrase distribution tasks or may personally perform non-supervisory tasks is found in the supervisor's position description, this does not mean casing of mail in letter carrier cases. Number 17. Supervisors may change labels on carrier cases. False. M document 204. Number 18. There is no provision to pay employees for time lost as a result of supervisors doing bargaining work. False. M document 206 and JCAM page 1-5. As long as such time is not de minimis, the employee who should have been assigned the work are paid for the time involved. Number 19. Supervisors are prohibited from delivering express mail. False. M document 870. Supervisors may deliver express mail, but only in accordance with Article 1.6. Number 20. Individuals who have been discharged or are awaiting disposition of their case may not bid for craft assignments. False. C432. National Arbitrator Mittenthal. Number 21. Full-time reserve or unassigned regular carrier who has opted for an assignment per Article 41.2.B.3 must work the duty assignment for the duration and may not bid on another full-time duty assignment. False. M document 669 and JCAM page 41-12. Such a full-time employee has the right to bid full-time duty assignments even though they're on the opt. If their seniority allows them to secure such a full-time bid assignment, then the individual is placed into such assignment according to Article 41, Section 1.C.3. The resultant vacant opt is then filled pursuant to the provisions of Article 41.2.B.3.5, provided there are 5 or more days remaining in the hold down. Number 22. A regular letter carrier who is temporarily disabled is not allowed to bid for and be awarded a full-time letter carrier bid assignment. False. M document 752. After an individual is awarded a full-time bid assignment as the result of exercise of their seniority, they are unable to immediately assume the duties therein. The Postal Service may require medical certification, which would indicate whether or not that individual will be physically able to carry the route within the first 6 months. If after 6 months the individual is still physically unable, medical certification may also be required for another 6-month period, which would indicate whether or not the individual will be physically able to do the duties of the position. After a year, if the individual is still physically unable to carry their assignment, then the bid is vacated and reposted per Article 41. That individual may not bid for the job. Number 23. Carriers may be designated a successful bidder not more than 7 times during the duration of this national agreement. False. Carriers may have additional bids for higher level positions, elimination or reposting of the employee's duty assignment, or when assigned to a station closer to home. Number 24. A letter carrier may designate the line of travel as approximate break location for street breaks. True. M document 138. Number 25. A street break may not be taken in the office. False. M document 424 and M document 527. Number 26. Breaks must be recorded on Form 1564 and shall have a specific time noted on the form as to when they must be taken. False. M document 134. Specific times must be indicated for lunches but not for breaks. Number 27. Breaks may not be taken in conjunction with the lunch period. True. M document 834. Number 28. A PTF will only be allowed to take a break if they work a minimum of 8 hours. False. M document 618. It is agreed that breaks can be taken on a pro rata basis, which would be 5 minutes for each 2 hours worked. Number 29. Personal comfort stops are deducted from total street time during route examinations. False. M document 242. Number 30. The union must furnish its own bulletin board if they desire one in the installation. False. Article 22. It is the employer's responsibility to furnish bulletin boards for each of the unions for their own use if space is available. Number 31. The union may not post the names of non-members on its bulletin board. False. See document 3224. The union may post names of non-members on its bulletin board as long as the Postal Service cannot prove that the material is unsuitable because it has caused or will cause an adverse impact upon the service to direct the workforce or manage its operations efficiently. Number 32. Recommended political candidates may be listed on NALC bulletin boards regardless of political affiliation. True. M document 1159. Number 33. If a casual works on Monday, well, we're going to skip the casual questions. After skipping the casual questions, we get to number 39. Management may work employees across craft lines without restriction in offices of less than 100 employees. False. See document 5959. The restrictions are found in Article 7 regarding management's right to work employees across craft lines apply regardless of the size of the office or any past practice to the contrary. Number 40. When management combines work from different crafts to make a full-time position, they must first get approval of the crafts involved. False. Article 7.2.a. Article 7 only requires management to inform the unions in advance of the reasons for combining such work. Number 41. RCAs are prohibited from working in the carrier craft. False. M document 1193. In emergency circumstances, RCAs can work in the carrier craft. Don't forget that's Article 3.f emergency. Also under a temporary dual appointment per ELM 323.61. An emergency is defined in Article 3F as an unforeseen circumstance or a combination of circumstances which calls for immediate action in a situation which is not expected to be recurring of nature. Number 42. Discipline must be corrective in nature rather than punitive. True. For most offenses, management must issue discipline in a progressive fashion. Progressive is demonstrated by issuing lesser discipline, such as letter warning, for a first offense, followed by a pattern of increasingly severe discipline for succeeding offenses. Number 43. Discussions with employees are not discipline and are not grievable. True. Article 16.2 and M document 548. It is important to note that any information about those discussions shall not be included in the employee's personnel file, and discussions are held in private. Also, instructions given during the discussion that violate the national agreement should be grieved. Number 44. A one-day count inspection may not be used as a sole basis to establish a standard against which a carrier's performance may be measured for disciplinary purposes. True. M document 829, M39 section 141.2 allows for a one-day count to determine office performance, but there is absolutely no contractual provision for a one-day count and inspection. Form 3999s may be completed throughout the year. Number 45. Linear daily volume estimates may not be utilized to constitute the sole basis for disciplinary action. True. M document 394 and 1444. The same remains true for estimates entered into DOAS. Number 46. Management may discipline a carrier for failure to meet the 18&8 casing standards. False. Document 386. The NALC's position has always been and remains that the only basis for disciplining a carrier relative to casing standards is unsatisfactory effort. Number 47. Disabled veterans who are employed by the Postal Service have additional protections relative to the use of sick leave and leave without pay. True. Document 165, 787, and ELM 514.22. Since 1930, there has been a legal protection for disabled veterans if they present a statement from their doctor proving that medical treatment is required. They will be allowed to take sick leave and leave without pay for their treatment without any penalty in efficiency ratings. Number 48. Where an employee meets the criteria of the M39 Section 271G and requests a special route inspection in writing, discipline for excessive office or street time is inappropriate. True. See document 5952 and see document 7603. Number 49. Emergency suspensions are subject to review and concurrence the same as regular suspensions. True. See document 5164. Number 50. Discipline must be effected within 14 days of the date it occurred. False. See document 1520, see document 7106, and JCAM 162. However, discipline must be timely without extended delays. 51. Absence for FMLA purposes may be cited in the issuance of discipline. False. See document 14107 and 29 CFR 825.220. FMLA absences are excused for up to a total of 12 weeks. No discipline may be issued based on FMLA leave. Number 52. Insubordination, in and of itself, is grounds for an emergency suspension. False. See document 10423 and see document 10293. Number 53. An employee may be removed at any time for a disability. False. See document 145 and article 16.1. No employee may be discharged except for just cause. Number 54. Management has no responsibility to reasonably accommodate a qualified handicapped person. False. Article 2.1. Article 2 creates a requirement that the Postal Service must reasonably accommodate qualified handicapped person because of the incorporation of the Rehabilitation Act of 1973 as amended in 1975. Number 55. If a grievance is filed protesting discrimination on the basis of one of the categories listed in Article 2, such grievance must be initiated at the informal A with the immediate supervisor. False. Article 2.3. Article 2, Section 3 states that discrimination grievance may be filed at formal step A within 14 days of the alleged discrimination. Number 56. If a carrier is discriminated against for reasons of race, creed, color, religion, national origin, sex, age, or marital status, the employee may file a grievance on this discrimination. True. Article 2.1. The carrier should also consider filing an EEO complaint. Number 57. Settlement of an EEO complaint bars further processing of a grievance on the same subject. False. M document 818, 770, and JCAM page 1611. Number 58. Management has no obligation to maintain DPS quality after obtaining the initial threshold percentage. False. M document 1225. 59. Management may only use current route inspection data in implementing DPS. True. M document 1221. Number 60. The Postal Service requires random drug tests of all present employees. False. M document 653. This provision prohibits across-the-board random drug testing of present employees under any circumstances. Number 61. The service may test certain drivers for drugs. True. MIPO 720-952. The Omnibus Transportation Employer Testing Act of 1991 requires alcohol and drug testing of safety-sensitive employees in the motor industry. The Department of Transportation published rules mandating anti-drug and alcohol misuse prevention programs in February of 1994. The February 1994 rules required that the implementation begin in 1995 for employers of 50 or more safety-sensitive employees. A safety-sensitive employee, for the purposes of those regulations, may be defined as one who holds a CDL and who drives a vehicle in excess of 26,000 pounds gross vehicle weight rating. Number 62. Linear measurement evaluations may be the basis for an Article 16.2 discussion concerning the letter carrier's efficiency. False. See document 4547. No discussion using linear measurement or DUVRs as a basis for discipline may be held pursuant to Article 16.2. The appropriate way to determine the office efficiency of a letter carrier is to apply M39 Section 1412, which allows one-day count. 63. Reference volume alone may be used as the basis to substantiate wrongful expansion of street time. False. M document 600. Number 65. The workload assessment process in certain instances may be used to replace the route inspection process. False. M document 1233. Number 66. A meeting with an EEO counselor may only be done off the clock and may not include the complainant's representative. False. M document 493 and EL 603 2.1.27.1.c. Both the complainant and the representative will be allowed reasonable time to meet with an EEO counselor as long as the meeting is held within the employee's regular working hours. Number 67. An EEO settlement automatically voids a grievance if the same issue or remedies are the same. False. M document 770. A union representative may not agree through the grievance procedure to nullify an EEO complaint without the EEO complainant's consent. Number 68. Probationary employees may not file a complaint with the EEOC regarding separation. False. Article 12.1.a restricts access to the grievance procedure regarding separation. However, the national agreement does not prohibit a probationary employee from exercising any other type of appeal. Number 69. An emergency is contractually defined as any incident which could not be foreseen. False. M document 105 and C 3633 and Article 3.f. Article 3.f defines an emergency as being an unforeseen circumstance or combination of circumstances which calls for immediate action in a situation which is not expected to be of recurring nature. Number 70. Management may refer an individual to the EAP program and require that continued attendance be condition of employment. False. JCAM page 35-2. EAP counselors are services available through voluntary self-referrals to letter carriers and their families. A management official may also refer an employee to EAP. However, participation is entirely voluntary. Article 35 includes joint understanding the EAP program and underscores the necessity of local branches to include in their defense of employees who are disciplined for any reason to attempt to determine or as soon as possible if the individual has an alcohol or drug problem. Number 71. Automobiles and contents of are covered under employee claims. False. Article 27. Such losses may be recovered through the filing of a tort claim. Number 72. Bicycles are considered privately owned vehicles for the purposes of Article 27. False. JCAM page 27-2 and M 1440. 73. An employee may not seek reimbursement for loss or damage to personal property while on duty or while on the postal premises. False. Article 27 in ELM 642. Number 74. Torn or ripped uniforms qualify for employee claims. True. See document 4462 and see document 2686. 75. An employee may file a claim under Article 27 for up to 6 months from the date of loss or damage. False. Article 27. An employee claim must be initiated within 14 days. Number 76. An employee may only file a grievance to challenge a letter of demand. False. ELM 437.1 and JCAM page 28.2. An employee, in addition, may file a Form 3074 available from within their installation head, requesting a waiver of an overpayment. Number 77. When a letter of demand is issued to an employee, the employee must immediately take restitution and then grieve for repayment. False. M document 1192. Article 28, Section 4 provides the employer will delay collection of the monies until disposition of the grievance has been made. Number 78. An employee may not be held financially liable for any loss, rifling, damage, wrong delivery of the mails, or failure to collect or remit COD funds if the employee exercises reasonable care. True. Article 28.2. Number 79. If a special delivery craft exists in an installation, they have exclusive jurisdiction over delivery of express mail. False. C 13863 and M document 870. Management has not designated the pickup and delivery of express mail to any specific craft. Number 80. The Postal Service may schedule a fitness for duty examination at any time per their discretion. False. ELM 864.32. The service's right in order fitness for duty examinations is limited under the FMLA. Number 81. An employee may not be scheduled for an FFD on their non-scheduled day. False. M document 356 and M document 94. The Postal Service may schedule employees for fitness for duty exams on non-scheduled days. Number 82. When an employee is called in for a fitness for duty on a non-scheduled day, the Postal Service must guarantee them 8 hours of pay. False. M document 94, M document 550, and M document 356. The Postal Service is allowed to pay these individuals only for the time taking the examination, including travel time. Number 83. In the case of a limited duty carrier, they may not be required to undergo fitness for duty during non-work hours. True. M document 1161. Number 84. Management may not issue forms locally nor locally revise existing forms. False. ASM 325.12. Such forms must be either promulgated or revised per Section 324 and 325 of the Administrative Support Manual. If such forms are not properly revised according to that section, then the forms are grievable and should not be allowed. Number 85. Form CA8 must be obtained by the employee from the Office of Workers' Compensation Program. False. M document 797. The Form CA8 should be available to all employees on all tours. Number 86. Only letter carriers may relabel cases and fill out the Form 313. True. See document 3329, M document 1377, and M document 967. Number 87. Form 1187 may not be filled out by employees on the clock. False. M document 317. Completion of Form 1187 is permitted by employees during orientation. Number 88. Form 1571 is a defunct form and should not be utilized by carriers. False. M document 413 and M41 131.44. Form 1571s are still in use and should be filled out on the day to which they apply. Number 89. Form 1723, which indicates an individual assigned to a higher level detail as a 204B, is to be sent to the regional office of the NALC. False. JCAM page 413 and M document 755. The local union shall receive copies of the Form 1723 as well as any modifications made due to premature ending of the employee's assignment or any other reason. Form 1750, which is utilized to evaluate probationary employees, may be used to evaluate employees who are not probationary. False. M document 20. Only probationary employees are evaluated using Form 1750. Number 91. Employees may be required to complete Form 2488 Authorization for Medical Report. False. M document 1441. The Privacy Act statement on the Form 2488 makes clear that completion is voluntary. There is virtually no reason why any employee should ever grant the Postal Service unfettered access to medical records. Number 92. An individual called in on their non-scheduled day may negate the Article 8 guarantees by filling out Form 3971 for personal reasons. True. M document 119, M document 879, M document 1210, and JCAM page 824. Management may not solicit employees to work less than their call-in guarantee, nor may employees be scheduled to work if they are not available to work the entire guarantee. However, an employee may waive a guarantee in case of illness or personal emergency. This procedure is addressed in the F-22, Section 22.14, and ELM, Section 432.63. Number 93. Only carriers should maintain Form 3982. True. M document 256. 94. A copy of Form 3996 may be requested by a carrier and shall be provided. True. M document 144. 95. Individuals who provide carrier assistance shall complete the lower portion of the Form 3996 as instructed on the form. True. M document 294. And M41 28.M. Number 96. A vehicle repair tag Form 4565 may be filled out the following day if the employee is in an overtime status. False. See document 6135. An employee must be allowed official time to complete the Form 4565 even if they are in an overtime status. Number 97. Local management may develop local forms provided that the local postmaster has authorized such form. False. M document 852 and M document 1156. This pre-ARB cites ASM 324.12. The ASM has been revised. The original language is now found in ASM 325. Number 98. Management may require carriers to write their leaving and return times on the carrier cases during the commitment process. False. M document 853. Number 99. Laws concerning wages, hours, and working conditions are not applicable to letter carriers. False. JCAM page 51. The National Labor Relations Act and other laws relative to the Postal Service are incorporated through Article 5 of the National Agreement into our contract. 100. Past practice should never be argued in the grievance procedure. False. Corey and Corey, Chapter 12, and JCAM pages 5-2. 101. Postal employee witnesses in arbitration hearing are paid for the time spent testifying at the hearing. True. M document 101. This is an accurate answer except that the Postal Service is not obligated to pay for overtime outside the schedule of the employee, nor would they be liable for pay on the non-scheduled day of a witness. Number 102. When the grievant is a veteran who falls under the Veterans Preference Act is issued a proposed removal as well as a letter of decision based on the same charges, it is unnecessary to grieve the proposed removal, but only the letter of decision. False. M document 304. 103. It is better to withhold information until formal A grievance meeting for its surprise effect. False. M document 166. During the informal A meeting, the parties are encouraged to jointly review all relevant documents to facilitate resolution of the dispute. It is the position of the MBA's office that any withholding of information, which the parties clearly had at the lower level, could be a possible argument of the service at arbitration for either arbitrary or capricious action on the part of the union, or provide the basis for a motion to exclude such evidence. 104. The grievant has no right to be in attendance at the informal A meeting. False. M document 223. 105. The presence of the grievant at the formal A grievance meeting is determined by the union. True. M document 790. 106. Management is required to pay the grievant for the time spent traveling to and from the formal A grievance meeting. False. See document 3214. 107. Union stewards are compensated not only for the actual meeting time at formal A, but also for travel time both to and from the meeting. False. M document 716. Number 108. A steward must write the actual appeal to Step B on their own time. False. See document 381. The steward's entitled to be paid for the time spent writing the appeals to Step B. Number 109. Witnesses at arbitration hearings are paid for the time spent testifying at the hearing. True. M document 101. 110. Management's liable for the payment of travel time for stewards and witnesses to and from the arbitration hearing. False. See document 4657 and JCAM page 1515. Number 111. Retired employees may not initiate grievances. True. Now this one's technically wrong now. There's one type of grievance that can be wrote by retired employees, but that will be an episode for a later date. Number 112. If an individual has left the service by either resignation, retirement, or death, the grievance of that individual is thereby barred from further processing. False. M document 226. 113. Decisions issued by regional arbitrators are precedent setting and must be followed by arbitrators dealing with the same issues in subsequent proceedings. False. JCAM page 1519, C 7233, and M document 1372. Decisions from regional arbitrators are cited only for persuasive value and not for precedent-setting value. That is, they are not absolute, and arbitrators who rule subsequently are free to pursue a decision other than that which has arrived at a regional arbitrator. On the other hand, national arbitration decisions are precedent-setting and regional arbitrators are bound by them. 114. If new information or argument is raised for the first time at arbitration hearing, then such information may not be considered by the arbitrator. True. See document 3319, see document 3206, see document 7621. However, arbitrator Aaron has held that the spirit of the rule against new arguments at arbitration should not be diminished by excessively technical construction. 115. Arbitrators have the authority to fashion remedies outside the scope of the national agreement to make the grievant whole. True. See document 3200. The whole issue of permissive remedies is a new area, but the principle, as most simply expressed, is there is no right without a remedy. The reasoning, simply put, is that there are many breaches of the agreement that the parties have not specifically stated what the remedy should be. Therefore, it is within the inherent rights of the arbitrator to fashion such a remedy, and such should be remembered as we write remedies in the grievance procedure. I'm going to stop at 115 just so this one's not too long, but that means the next one's going to be really long. I might cut out some of the questions though. But how many of those did you get correct? Study up, guys, because we're going to be getting back to hitting the books. Next episode, which I think might be released on Wednesday, will have the rest of the Black Book. Hopefully you learned something valuable today, and as always, have a good day.
Shout out to the Roseville Wrecking Ball. He is an Article 8 scholar, and thank God, we need Article 8 scholars right now. The Grievous Genius and the Roseville Wrecking Ball doing amazing work.
Brothers and sisters, this guy is good, man. He's fucking good.
And my boy Joshua, he killed it. Man, he's lockstep right now. He's killing it.
You would think this guy has been around for 30